I'm joined now by Senior Advocate of Nigeria, Monday Ubani, who has raised concerns about INEC's interpretation of this law and even questioned the Commission's public explanations earlier today. Mr. Ubani, thank you for joining us on the program this evening. You referenced INEC Chairman's interview earlier today and also suggested some key questions were not answered. What exactly, in your opinion, did INEC fail to clarify? And why is that significant?
Yeah, thank you very much for having me. I hope I'm being heard.
Clearly, sir.
Okay, fine. I took time to read the very elaborate statement of INEC explaining the reasons for the actions they took concerning the judgment of the Court of Appeal. They were very elaborate, and I saw some sense in what INEC said. Then this morning, an INEC chairman was interviewed by Dr. Ruben Abati on Arise, and I took time to listen to the conversation. But there was this one vital issue that the chairman himself did not clarify to my own satisfaction. He took the position like, in the light of the litigation that is going on and different letters that were written by the counsel of the various parties to him, he felt that the best thing for INEC to do in this circumstance was to just don't take any sides and allow the judicial interpretation of what is actually going on to play out so that they can now take a position. I love that they didn't want to interfere. They don't want a situation where they will side with one party. At the end of the day, the court will nullify whatever process that have taken place in the light of the preservative order of the court. I listened to him very carefully, but there is one thing he did not satisfy me in clarifying, and that is the issue of removal of the leadership of ADC from the website of INEC. Prior to that particular decision, they recognized the leadership of David Mark, and it was in their website. Now, when the court now says, look, everyone should maintain the status quo ante bellum, and there was somebody already recognized by INEC and all that, INEC would have allowed that particular name to remain until the decision of the court says, because there was no court order.
Which name are you referring to specifically, Mr. Bani?
David Mark. David Mark's name was recognized by INEC in their website. But immediately that judgment was pronounced, I heard that the name was removed from the website. So signifying that INEC has taken sides. Because if INEC says we want to maintain neutrality in the entire process, we want a situation where the court will be in a position to make a pronouncement, giving us a clue as to who we should side. INEC should have allowed things to remain the way they were until that judgment is pronounced by the court, because there was no judgment by the Court of Appeal saying recognize this faction or do not recognize this particular faction. So by removing the name that was already in the system, that was taking side, and that did not in any way probably go well with me. In terms of explanation, as I said earlier, INEC was very elaborate in explaining what made them took the decision they took. And if you see their reason, it makes some level of sense. Look, we don't want to take any side with any person. We want to remain neutral.
Senior Advocate
makes a pronouncement.
Let us test the alternative here. If INEC had continued to recognize the David Mark leadership, even goes ahead to monitor their Congress or accepting correspondence, could that not also be seen as helping one faction to foist a fait accompli in the court?
You don't understand. My problem is that when somebody files an action in court and there is no pronouncement of the court to the contrary, you don't take any decision. There's no court order. Somebody filed a motion ex parte and then filed a motion on notice, putting everyone on notice. That does not in any way translate to any judgment of the court. There's no ruling. The point is that you have brought the matter before the court. Until the court makes a pronouncement, every party will remain as it were. So if there has been no judgment saying INEC should not recognize their monitoring of their primaries and all that, then INEC is not in a position to now say, I'm not going to monitor, because there is no express order. There is no directive order from the court saying don't recognize it. It's only that somebody has gone to court challenging the fact that you should not. unless a court makes a pronouncement, then INEC has no right to take, oh, I'm not going to recognize, I'm not going to do this, or remove the name of the person that was already there. Because in that wise, I'm only following INEC's explanation. INEC is telling Nigerians, look, we're not taking side. We want to remain neutral. Then if you want to remain neutral, then go ahead and remain neutral. Do not take side with any person until a pronouncement is made.
All right.
In any case, are we not even aware that issue of leadership of political party is not supposed to be decided by the court? The court has always held anything that has to do with your leadership is an internal matter. Go and resolve the issue and come back and all that. Don't bother us with all internal matter and all that. But I'm seeing now an interference now, the court coming in order to resolve the issue of leadership. So sometimes these things require some level of clarity in terms of our jurisprudence. Most times they say, oh, courts matter. Courts do not in any way interfere with internal matters of the political party. But we're also seeing courts coming in matters that are purely internal. So it gives a lot of concern as to what is the pronouncement of court with regards to internal matters of the political party.
Perhaps you should take us to the classroom for a minute, if you will. This phrase, status quo ante bellum, is at the heart of the disagreement here. In clear terms, what should the status quo actually refer to in this case? Before the suit or after the leadership changes?
This particular, somebody called now to distract me.
It's all right.
My God.
But I can hear you. We can still hear you, Mr. Ubani. Yes, I can hear you clearly. Please go ahead.
Yeah, somebody called in order to distract. I'm very sorry about that.
I was asking that you should explain what the status quo should be. All right, please go ahead.
I heard you loud and clear. What I'm saying is, that particular phrase has caused so much problem that I think by now, the Nigerian judiciary must go a bit further. Whenever they make a pronouncement as the status quo antebellum should be maintained, to say what we mean is this, so that it doesn't give room for all this multiple interpretation we get over the time. Over years, we have been having this issue. The other party will say this is what the court, meant. The other person will be giving his own interpretation of what the court meant. So what stopped the court from saying, what I mean by this is that we recognize the leadership prior to the removal or resignation of the ADC stalwarts, handing over to David Mark, or we recognize David Mark's leadership pending the time this person has come to court and all that. They should go further, because this particular word has given room for multiple and then sometimes vague and complex interpretation. And I think we now have to develop our jurisprudence in such a manner that the court should be able to go forward and say, this is what I mean by this. So in that wise, you don't give room for any multiple interpretation anymore. So that is what I think. So I think that the court should have done, if the court has done this, we won't be in this quagmire where we are in this particular matter over this issue. That is what I think. But I think before hostility breaks, that is what it means, antebellum. Before hostility breaks, at what point? Is it at the time the man went to court in September? Remember that he was said to have resigned in May, according to them. And there was a pronouncement to that effect. So why did he have to wait until September? If he resigned and these guys were handed over power as far back as July, what was he doing until September when he now began to challenge the fact that he was supposed to be the chairman that would have handed over?
He said that letter of resignation was fake, that he didn't sign it.
Yes, that is what he's saying. So I'm also very worried. If that letter is fake, then ADC people have done the wrong thing. They were supposed to carry all the leadership along if they want a new person to now head ADC. And they were handing over to a new person. They would have made sure that all the leaders signed out and said, we are agreeing with the new leadership. So why did they have to wait? Why did they have to commit such an error? And then this man now comes up and says he did not resign. So why would they have committed such an error? So that is where I'm really, seeing some error on the part of ADC. Why did they not carry everyone along?
Mr. Ubani,
they have to wait until the man raised the issue. I was not carried along. I didn't resign. And that was in September.
We have a new electoral law and by extension, a new INEC guideline. We saw how that affected the PDP and, ensure that they found a common ground before their national convention, at least by order of the court. Given the time frame, what options now, do the ADC have if they decide to go? Because INEC says it's waiting for the decision of the Federal High Court. We understand that can be appealed in 2 higher courts, right? Do they have the time?
They don't they don't have that much time. But what I think they should do in the honestly, I'm worried for them. I am completely worried because I had thought that ADC should have taken a proper legal procedure when they call, say, come and explain to me why I will not make an order restraining you people from. They would have filed whatever they wanted to file in order to explain the court that no, you can't make this order, and you can't make this order because this man has resigned. Right? I don't know why they went on appeal. Instead of responding to that particular, query that the court said, look, I am going to come and tell me the reason why I shouldn't grant this interlocutory order. They should have responded to it. But the next thing I hear is that they went on appeal. What were you appealing against? That again. But I think that the Federal High Court can summon this, really abridge time, and then probably hear this matter, either on Tuesday, and then take a decision. And whatever decision is taken, even if any person wants to go on appeal, then there is express order made. The court now will, an INEC will obey that order. If you say go and monitor, it goes to monitor. If you say don't go and monitor, now you will not go and monitor. But I think that there must be a way. The Nigerian judiciary must live up to expectation by knowing the urgency of this and knowing the implication, both political and economically, for us as a nation, even for our democracy. There is no way we can have only one political party to contest 2027 general election. It's not healthy for us as a nation. It doesn't paint us in good light. It doesn't put us that the world respects us. If we don't have any opposition for 2027, there must be an election in which other parties will be allowed to contest. If you don't do it, you are destroying Nigeria. So the judiciary must now realize the importance of this particular case and summon all the parties to come out on Tuesday in order to take a decision one way or the other concerning this matter. It is for the health of our nation. It is for our democratic journey. And it is also important that the world doesn't see us as a country that is not serious. I am not happy with what has happened. The step that was taken by ADC by going on appeal in a matter that requires a simple explanation. I don't know who advised them on that, but whatever it is, now the only way to really get them out of this mess is that the court can abridge the time and hear this matter and take a decision one way or the other so that we can know whether they can monitor their primary. Without that monitoring, without this timeline being complied with, we are in trouble of not having any opposition for 2027 general election. And that's healthy for us as a nation. Yes.
Let us step back from ADC for a minute because we have to go in about 3 minutes thereabout. We are hearing calls for the INEC chairman to resign. The commission says it's not troubled by it. But does this situation raise broader concerns about how INEC may handle disputes as we approach the 2027 elections? And what should the commission be doing immediately to restore confidence and avoid further controversies like this?
Yes, INEC has a lot to do in terms of restoration of confidence, of all other stakeholders in the entire electoral process. You must show evidence of that you are independent. And as I said earlier, where I faulted INEC in all this, they gave very good explanation why they took the step they took. But my problem is, why do you have to remove somebody who was already there if you said you are not going to take any side? You have taken side by removing his name from the website. So INEC must show that level of neutrality, level of independence, and ensure that confidence is restored. Because why do we have to waste all the billions? If people will not have confidence in INEC conducting a free and fair and credible election in 2027, it's very important for us as a nation. And so that restoration of confidence that you are independent and that you are not being teleguided and nobody is manipulating you is important for us to have an election that people will believe has a level of confidence clearly restored on it as an institution. It's an unbiased institution, and they should be able to do that particular duty that will restore that issue of confidence. I think they have a lot to do, and I believe them. And today, that was the first time he granted an interview. Since he was sworn in, he has never did, and I was happy that he was very explicit in his explanation. But the only thing that I fault him, I keep on saying it, is why do you have to now take side by removing his name, somebody's name from you would have allowed the whole thing to let the court make a pronouncement. But I think INEC has a lot to do in terms of restoration of confidence, to answer your question.
Interestingly, the name was on the website on the day INEC released that particular publication, and it was removed the following day. I understand that perhaps some administrative work had to be done. Senior Advocate of Nigeria, Monday Oyekachi Ubani, thank you for your insight.
Thank you for having me. Good evening.
What started as a party dispute has now risen deeper questions about law, interpretation, and trust in Nigeria's electoral system. And as 2027 draws closer, those questions will only get louder. We'll be here to ask them. I am Nifemi Oguntoye. You can watch it again at midnight and 6 a.m. tomorrow. See you again at the top of the hour.